All right, settle down, everyone. Welcome to today's explainer lecture. KSLU law students, open your notebooks and pay strict attention. Today, we're not just discussing abstract legal theory. I'm going to provide you with the absolute, foolproof mental blueprint to score maximum marks on a 16-mark university question regarding the Transfer of Property Act. Specifically, we're going to completely conquer the core distinction between vested and contingent interests. Listen, if you follow my structural instructions today, word for word, you will leave the evaluator no choice but to award you top marks. Okay, let's dive right into this crucial syllabus topic.
Here's exactly what we're covering today. 1. Introduction to Property Transfer. 2. Vested Interests Section 19. 3. Contingent Interests Section 21. 4. Distinguishing Vested and Contingent. 5. Landmark Case Law Breakdown. And 6. Conclusion and Key Principles. Now, map this exact synopsis out on the very first page of your blue books before writing a single paragraph. Doing this will immediately secure the evaluator's approval because it shows a highly organized, disciplined legal mind. Let's move to our first structural heading.
Write this heading boldly at the center of your page. 1. Introduction to Property Transfer.
The distinction between vested and contingent interests is a key concept under the Transfer of Property Act 1882, particularly under Sections 19 and 21. Write that down exactly as stated. Now, why is this important? Because citing the exact statute year, 1882, and explicitly mentioning Sections 19 and 21 right off the bat is a guaranteed marks fetcher. It tells the examiner immediately that you actually know your bare acts. Never, ever start a property law answer with a vague philosophical preamble. Hit them with the statute and the section numbers immediately.
Moving on, direct your pens to underline this precise heading on your answer scripts. 2. Vested Interest, Section 19.
Let's look at the strict statutory language. A vested interest is an interest created in favor of a person without any condition precedent, and it takes effect immediately or on the happening of a certain event. Okay, put your pens down for a second and just listen. The absolute core of this lies in dissecting two specific phrases. First, without any condition precedent. This simply means there's no hurdle to jump over. There's no prerequisite to fulfill before the right is created. Second, the phrase certain event. The law doesn't say it has to happen today, but the event triggering the enjoyment of the property must be mathematically, universally certain to happen eventually. Emphasize these exact phrases in your exam to show you truly understand the statutory mechanics. Next, you need to break down the features sequentially. No condition precedent. Creates present and fixed right. May be enjoyed later, but ownership exists now. And not defeated by death of transferee. Listing these unmerged, distinct points sequentially demonstrates a highly structured legal mind to the KSLU examiner. Please do not write a messy paragraph. Bullet points force clarity. Let me elaborate on that third point. May be enjoyed later, but ownership exists now. You own the title today, even if you literally cannot possess the land until next year. The title is locked in. And because it's locked in, as the fourth point clearly states, it's not defeated even if the transferee tragically dies. The property will simply pass on to their legal heirs.
Now mark my words, an answer without an illustration is incomplete. Note this standard illustration down. Property transferred to A for life and after A's death to B. B gets a vested interest because it's certain to happen. Let's break that down. Why? Because death, unfortunately, is a universal certainty. A will die. It's a fact of human existence, not a mere possibility. Therefore, B's right to take the property after A's death isn't conditional upon some maybe. It is fixed right now. B is the ultimate owner today. Their enjoyment is just postponed until A passes away. Firmly cement this logic in your head.
Okay, move to the next major heading in your structural blueprint. Title it 3. Contingent Interest Section 21.
Let's read the definition verbatim. A contingent interest is an interest which depends upon the happening or non-happening of an uncertain event. Notice the sharp contrast here, right? I demand you highlight this fundamental difference in your blue books. Under Section 19, we spoke of a certain event. But here, under Section 21, the entire legal right hinges on an uncertain event. It's essentially a game of chance. If the event doesn't happen, the interest simply evaporates into thin air.
Note down these exact features. Subject to condition precedent. Creates uncertain right. May or may not become vested. Fails if condition not fulfilled. Let me elaborate on this. The mere presence of a condition precedent makes this legal right inherently unstable. It's entirely conditional. You don't own it now, you only have a hope of owning it if the specific condition is met. if the condition fails. For instance, if the uncertain event becomes physically impossible to fulfill, the contingent interest completely fails. It is entirely wiped out.
Here's your illustration for Section 21. Property transfer to A if B marries C. A's interest is contingent on marriage. Let's really think about why. Marriage between two specific individuals, B and C, is highly uncertain. They might break up, right? They might marry other people, or one might pass away before a wedding even takes place. Because this marriage is an uncertain event that may never occur, A's interest is purely contingent. Until B and C actually sign the marriage register, A has zero fixed rights to that property.
Next heading, 4. Distinguishing vested and contingent. Get ready to draw a strict, high-contrast ruled table in your answer script for this one.
I'm going to read this entire matrix row by row, and you are going to memorize it. First basis, nature. Vested interest is certain, while contingent interest is uncertain. Second, condition. Vested interest has no condition precedent. Contingent interest is subject to condition. Third, right. Vested interest is a present fixed right. Contingent interest is a conditional right. Fourth, transferability. Vested interest is transferable. Contingent interest is generally transferable but uncertain. Fifth, effective death. Vested interest passes to heirs, while contingent interest may fail. Listen to me. KSLU evaluators actively look for this exact tabular clarity. Do not write this out in long, winding paragraphs. A table demonstrates complete mastery of comparative jurisprudence. Memorize these 5 basis points.
Moving to Section 5, Landmark Case Law Breakdown. Pay very close attention here. In a KSLU law examination, an answer without a deep case law analysis is simply an incomplete answer.
Write down our first landmark case, exactly as it appears. Lachman v. Baldeo, which emphasized preference for vested interest over contingent interest. Now, pause your writing and just listen to me for a second. You must write this case name in a separate boxed format to immediately capture the evaluator's attention for a 16-mark answer. Let me explicitly detail the background facts and relevance so you can explain it. In the background of Lachman versus Baldeo, the dispute arose because a property transfer document was drafted with highly confusing, ambiguous conditions, leaving it totally unclear whether the transferee had an immediate right or a conditional one. The final ratio decidendi, the binding verdict of the court, firmly established that Indian courts must actively presume a vested interest rather than a contingent one whenever the language permits it. And what's the absolute relevance of this case to our discussion? It establishes the fundamental judicial policy that the law absolutely abhors property rights being held in an uncertain vacuum. It matters because it forcefully instructs future courts on how to interpret poorly drafted wills and deeds.
Our second mandatory citation. Write it down. Rama Rao v. Ranga Rao. This clarified the distinction between vested and contingent interests. Again, heavily underline this case name. Let me give you the background facts for your deeper understanding. In this dispute, the timeline of exactly when property rights actually accrued was heavily contested based on a complex condition precedent placed on the heirs. The Supreme Court's ratio decidendi here painstakingly separated the present fixed right of Section 19 from the conditional right of Section 21. The verdict created a clear judicial litmus test to determine if a condition actually suspends ownership entirely or if it merely postpones the physical enjoyment of the land. Why does this matter fundamentally for Indian property law? Because before this clarification, many families were tied up in literally decades of litigation over inheritance timelines. This case brought strict definitional boundaries to the Transfer of Property Act, providing much-needed clarity for lower courts.
All right, we've reached the final structural element of your exam answer script. Heading 6, Conclusion and Key Principles.
Write down this exact quote. Law favors vesting over contingency. This is an authoritative, indisputable legal maxim. I instruct you to underline this principle heavily in your conclusion. It is the golden thread running through the entirety of property law. The courts want clear, definitive owners. They do not want property suspended in a constant state of what if.
Therefore, logically following that, if ambiguity exists, it is interpreted as a vested interest. This is exactly how legislative intent operates in the real world. If a lawyer drafts a deed clumsily and the judge honestly cannot tell if Section 19 or Section 21 applies, the judge will always lean towards Section 19. The legislative intent always leans towards ensuring economic and social stability in property transactions.
Write out these conclusion points verbatim to close your answer. Vested interest provides certainty and immediate ownership. Contingent interest depends on uncertain conditions. Law prefers vested interests to ensure stability. Summarizing these 3 precise points perfectly ties together your entire 16-mark answer script. It explicitly shows you understand the definitions, you understand the differences, and you grasp the overriding judicial philosophy.
I'm going to leave you with this final practical question to think about. If you draft a property transfer ambiguously, will the court side with certainty or condition? Based on our explainer lecture today, you all should know the answer. The court will ruthlessly side with certainty. It will force a vested interest. Keep this in mind not just for your KSLU exams, but for your future practice as competent legal draftsmen. Master this structure, cite the sections precisely, box those landmark cases, and you will undoubtedly secure maximum marks. Class dismissed.